argument this morning in Case 23-726, Moyle versus United States, and the consolidated case. Mr. Turner.
Thank you, Mr. Chief Justice, and may it please the Court. When Congress amended the Medicare Act in 1986, it put EMTALA on a centuries-old foundation of state law. States have always been responsible for licensing doctors and setting the scope of their professional practice. Indeed, EMTALA works precisely because states regulate the practice of medicine. And nothing in EMTALA requires doctors to ignore the scope of their license and offer medical treatments that violate state law. 3 statutory provisions make this clear. First, Section 1395, the Medicare Act's opening provision, forbids the federal government from controlling the practice of medicine. That's the role of state regulation. Second, Subdivision F in EMTALA codifies a statutory presumption against preemption of state medical regulations. And third, EMTALA's stabilization provision is limited to available treatments, which depends on the scope of the hospital staff's medical license. Illegal treatments are not available treatments. Add in this Court's own presumption against preemption of state regulations, combine that with the need for clear and unambiguous spending clause conditions, and the administration's reading becomes wholly untenable. The administration's misreading also lacks any limiting principle. If ER doctors can perform whatever treatment they determine is appropriate, then doctors can ignore not only state abortion laws, but also state regulations on opioid use and informed consent requirements. That turns the presumption against preemption on its head and leaves emergency rooms unregulated under state law. It's unsurprising that no court has endorsed such an expansive view of EMTALA. And until Dobbs, nor had HHS. Everyone understands that licensing laws limit medical practice. That's why a nurse isn't available to perform open heart surgery, no matter the need, no matter her knowledge. The answer doesn't change just because we're talking about abortion. The Court should reject the administration's unlimited reading of EMTALA and reverse the district court's judgment. I welcome the Court's questions.
Normally, when we have a preemption case, there's some relationship between the parties. Is the state being regulated by the federal government under EMTALA, or is the state engaged in some sort of quasi-contractual relationship?
Yes, Your Honor. In this case, the state, Idaho, for example, has no state hospitals that participate with the emergency rooms in EMTALA. And so in this case, there isn't even a quasi-relationship. The parties being regulated by EMTALA here are hospitals and doctors. And I think your question is getting at the Armstrong issue. And we think that is a significant question. It wasn't part of the question presented. We think the Indiana amicus brief raises significant questions and deals with that argument well. But the question presented here is one of direct conflict between Idaho's law and EMTALA. And on that question, we don't think it's hard at all. And, Your Honors, going to that direct conflict, I think if you consider the express limitation within the statute of availability.
Well, before we do that, can I just step back and get your understanding of the statute? You made some representations as to how you see it working, and so let me tell you what I think, and then you can tell me whether you agree, disagree, or otherwise. So I think that there are 2 things that are pretty plain on the face of this statute. One is that EMTALA is about the provision of stabilizing care for people who are experiencing emergency medical conditions. That's one thing I think the statute is doing. And I also think that it is operating to displace the prerogatives of hospitals or states or whomever with respect to that fairly narrow slice of the healthcare universe. This idea of emergency medical services is like one very minor part or small part of the sort of overall healthcare provision of healthcare. So what that means is that when a hospital wants to only provide stabilizing care in emergencies for people who can pay for it, for example, EMTALA says, no, I'm sorry, you have to stabilize anyone who's experiencing an emergency medical condition. Or when a hospital wants to provide stabilizing treatments to people who are experiencing only certain kinds of emergency conditions, EMTALA says, no, here's the list of conditions, and you have to provide stabilizing care for those people. Similarly, if a state says, look, it's our job to govern all of health care in our state, and we say that only certain kinds of health care can be given to people who are experiencing emergency medical conditions. We don't want whatever treatment. We want only certain kinds of treatment. EMTALA says no. We are directing that as a matter of federal law, when someone presents with an emergency condition, they have to be assessed, and the hospital must do whatever is in its capacity to stabilize them. Is that your understanding of the statute?
Partially, Your Honor. We agree that EMTALA does impose a federal stabilization requirement, but the question here is, what is the content of that stabilization requirement? And for that, you have to reference state law.
Okay, well,
I think what you just said is important, because when you concede that EMTALA imposes a stabilization requirement, it is this statute, the federal government, interfering, if you will, in a state's health care choices. So EMTALA is on its face a statute that says it's not all the state's way. There are federal requirements here. There is a requirement to stabilize emergency patients. And you agree with that?
Yeah, Justice Kagan, we agree that EMTALA's purpose was narrow to bridge this gap that existed in some
Okay,
states.
so
and
I mean,
failure
we
to
can
treat.
just take off the table this idea that, just because it's a state and it's health care, that the federal government has nothing to say about it. The federal government has plenty to say about it in this statute. Now, you're right. Now there's a question of what's the content of this stabilization requirement. And as far as I understood your opening remarks, you say, well, this is left to the states. But if I'm just looking at the statute tells you what the content of the stabilization requirement is. It's to provide such medical treatment as may be necessary to assure within reasonable probability that no material deterioration of the condition is likely to occur if the person were transferred or didn't get care. So it tells you very clearly it's an objective standard. It's basically, it's a standard that clearly has reference to accepted medical practice, not just whatever one doctor happens to think, but here's the content of the standard. You have to stabilize. What does that mean? It means to provide the treatment necessary to assure within reasonable medical probability that no material deterioration occurs.
Yeah, let me respond in two ways. First, the objective standard that you set forth there and that understanding is contrary to the administration's view. They say it is a totally subjective standard, and whatever treatment a doctor determines is appropriate.
I think that's not true. I mean, I think you guys can argue about this yourself, but as I understand the Solicitor General's brief, and we'll see what the Solicitor General says, but the Solicitor General says it's not up to every individual doctor. This is a standard that is objective, that incorporates accepted medical standards of care.
Well, and the more fundamental point is the definition that you quoted of stabilizing care in the operative provision in B1 is also textually, explicitly qualified by that which is within the staff and facilities available at a hospital.
Yes, and
so
That's quite right. That's quite right. It says within the staff and facilities available at the hospital. And if you just look at that language, I mean, it's absolutely clear that that's not a reference to what state law involves. The staff and facilities available. If you don't have staff available to provide the medical care, then I guess you can't provide the medical care. If you don't have the facilities available to provide the medical care, then you can't provide the medical care. A transfer has to take place for the good of the patient.
This is a really important...
The availability here, because it's the availability of staff and facilities. It's, do you have the right doctors? Do you have enough doctors? Do you have the right facilities? Or is it better for the patient to transfer them to the hospital a few miles away?
You're exactly right. Do you have the right doctors? How do you answer that question except by reference to state licensing laws?
But you absolutely can't do that. I mean, that's the sort of the initial point that I was trying to make, which is that the federal mandate is to provide stabilizing care for emergency conditions regardless of any other directive that the state has or the hospital has that would prevent that care from being provided. That's the work of the statute.
Justice Jackson, that's not even HHS's conclusion. In the State Operations Manual, which they proffered on page 36 of the brief, It defines what makes a staff person available under the statute, and they say it has to.
And does it say that they're not available if state law doesn't allow this procedure?
It says they are available to the extent they are operating within the scope of their medical license, and that is our argument. They want to now draw it far more narrow and look only at physical availability. We agree, that's the component, but there's also a legal availability component here, too.
Counsel, the problem we're having right now is that you're sort of putting preemption on its head. The whole purpose of preemption is to say that if the state passes a law that violates federal law, the state law is no longer effective. So there is no state licensing law that would permit the state to say, don't treat diabetics with insulin. Treat them only with pills, metformin. And a doctor looks at a juvenile diabetic and says, without insulin, they're going to get seriously ill. And the likelihood, and I don't know what that means under Idaho law, we'll get to that shortly, because, I don't know, we believe this is a better treatment.
Yeah.
Federal law would say, you can't do that. Medically accepted, objective medically accepted standards of care require the treatment of diabetics with insulin. The medically accepted obligation of doctors when they have women with certain conditions that may not result in death, but more than likely will result in very serious medical conditions, including blindness for some, for others the loss of organs, for some chronic blood strokes. Idaho is saying, unless the doctor can say in good faith that this person's death is likely, as opposed to serious illness, they can't perform the abortion. So I don't know your argument about state licensing law, because this is what this law does. It tells states your licensing laws can't take out objective medical conditions that could save a person from serious injury or death.
Yeah, I think there are two crucial responses to your point. Let me begin with the preemption point. Subdivision F and Section 1395 actually are telling HHS, the federal government, and courts just the opposite, that you
No,
don't...
it's saying you can't preempt unless there's a direct conflict. If objective medical care requires you to treat women who present the potential of serious medical complications, and the abortion is the only thing that can prevent that, you have to do it.
No.
Idaho law says the doctor has to determine not that there's merely a serious medical condition, but that the person will die.
Yeah.
That's a huge difference, counsel.
We agree that there is daylight between how the administration is reading EMTALA and what Idaho's Defensive Life Act permits. We agree that there is a controversy here, but what I'm saying is that...
No. There's more than a controversy. Because what you're saying to us is if EMTALA doesn't have preemptive force, then not just Idaho, it has a saving condition for abortions when it threatens a woman's life. But what you're saying is that no state in the nation, and there are some right now, that don't even have that as an exception to their anti-abortion laws. What you are saying is that there is no federal law on the book that prohibits any state from saying, even if a woman will die, you can't perform an abortion.
Your Honor, I know of no state that does not include a life-saving exception. But secondly,
Some
the government...
have been debating it at least. And if I find one, but your theory of this case leads to that conclusion.
I think our point is that EMTALA doesn't address
Does
that very...
your
Could I,
theory...
could I hear your answer?
Yeah. In the administration's reliance on a standard like best clinical evidence or some national norm, I think that's very fraught, because what it really is saying is the text itself doesn't address what stabilizing treatment is required. You go outside the text to professional standards that are floating out there that might change day to day, and that really boils down to a question between a conflict between what the ACOG says and what Idaho law says, and that's
Thank
not
you. Thank you, Counselor.
Actually, can I just clarify, because I'm not sure I understand? You know, sort of looking at this from a broader perspective, it seems to me that EMTALA says you must provide whatever treatment you have the capacity, meaning staff and facilities, to provide to stabilize patients who are experiencing emergency medical conditions. Idaho law seems to say you cannot provide that treatment unless doing so is necessary to prevent a patient's death to the extent the treatment involves abortion. Why is that not a direct conflict? You must in a certain situation, that's what the federal government is saying, and you cannot if it involves abortion, says Idaho.
I think the nurse example really highlights the reason why. Because a nurse might be available. The nurse may even think she knows how to. And under the flat must provision in EMTALA, the administration's reading would say, call her into action, put her into the operating room, and open the patient up. But
right,
that is
and
not...
and Idaho would say, no, that's still a conflict. So fine, let's say the administration's position is that nurse can do it. Are you suggesting that federal law would not take precedence, would not preempt a state law that says, no, she can't?
Well, whether federal law could do that is a different question than whether EMTALA here does do that. And I think the answer is clear that it doesn't. I mean, it's like the Gonzalez v. Oregon case, where the Controlled Substances Act, this court noted that was the provisions there rely upon and assume a medical profession being regulated by state police powers. That's the same with EMTALA. EMTALA is a 4-page statute. Congress didn't attempt to address the standards of care for every conceivable medical treatment.
It definitely didn't address the standards of care. It did leave that to the medical community. It said, Congress was not going to address every treatment for every condition. But it said you do what is needed to assure non-deterioration. So I guess the question here is, do you concede that with respect to certain medical conditions, an abortion is the standard of care?
No, because the standard of care in Idaho, there's a life-saving exception for certain abortions, and that is the standard of care. And the standard of care is necessarily set and determined by state.
Well, I think you have to concede that with respect to certain medical conditions, abortion is the standard of care because your own statute, as interpreted by your own courts, acknowledges that when a condition gets bad enough such that the woman's life is in peril, then the doctors are supposed to give abortions. And the reason that that's true is that with respect to certain rare but extremely obviously important conditions and circumstances, abortion is the accepted medical standard of care. Isn't that right?
Yes, and that was my point, that there is a life-saving exception under Idaho law. Now, the question here is...
Now the question is it also the accepted standard of care when, rather than the woman's life being in peril, the woman's health is in peril? So let's take, all of these cases are rare, but within these rare cases, there's a significant number where the woman her life is not in peril, but she's going to lose her reproductive organs. She's going to lose the ability to have children in the future, unless an abortion takes place. Now, that's the category of cases in which EMTALA says, my gosh, of course the abortion is necessary to assure that no material deterioration occurs. And yet Idaho says, sorry, no abortion here. And the result is that these patients are now helicoptered out of state.
Yeah. Your Honor, the hypothetical you raise is a very difficult situation. And these situations, nobody's arguing that they don't raise tough medical questions that implicate deeply theological and moral questions. And Idaho, like 22 other states, and even Congress and EMTALA, recognizes that there are two patients to consider in those circumstances. And the two-patient scenario is tough when you have these competing interests.
You know, that would be a good response if federal law did not take a position on what you characterize as a tough question. But federal law does take a position on that question. It says that you don't have to wait until the person is on the verge of death. If the woman is going to lose her reproductive organs, that's enough to trigger this duty on the part of the hospital to stabilize the patient. And the way to stabilize patients in these circumstances, all doctors agree.
And Idaho law does not require that doctors wait until a patient is on the verge of death. There is no imminency requirement. There is no medical certainty requirement.
I'm sorry, answer the following question, and these are hypotheticals that are true. Hold on one second, and you can tell me whether Idaho's exception, and we still go back to the point that even if Idaho law fully complies with federal law, you have a pregnant woman who is early into her second trimester at 16 weeks, goes to the ER because she felt a gush of fluid leave her body. She was diagnosed with PROM. The doctors believe that a medical intervention to terminate her pregnancy is needed to reduce the real medical possibility of experiencing sepsis and uncontrolled hemorrhage from the broken sac. This is a story of a real woman. She was discharged in Florida because the fetus still had fetal tones, and the hospital said she's not likely to die, but there are going to be serious medical complications. The doctors there refused to treat her because they couldn't say she would die. She was horrified, went home. The next day, she bled. She passed out, thankfully taken to the hospital. There, she received an abortion because she was about to die. What you are telling us, is that a case in which Idaho, the day before, would have said it's okay to have an abortion?
Under Idaho's life-saving exception, a doctor could in good faith, if the doctor could in good faith medical judgment determine...
No, I'm asking you. The Florida doctor said, I can't say she's going to die.
Yeah, and Your Honor, my point is...
If your doctor says, I can't with a medical certainty say she's going to die, but I do know she's going to bleed to death if we don't have an abortion, but she's not bleeding yet, so I'm not sure.
The doctor doesn't need to have medical certainty. The Idaho
Counsel,
Supreme Court
answer
answered that
yes
question.
or no. Cannot say that there's likely death. He can say there is likely to be a very serious medical condition, like a hysterectomy.
Based on the
Let me go to another one. Imagine a patient who goes to the ER with pre-prompt, 14 weeks. Again, abortion is accepted. She was in and out of the hospital up to 27 weeks. This particular patient, had to deliver her baby. The baby died. She had a hysterectomy, and she can no longer have children. All right? You're telling me the doctor there couldn't have done the abortion earlier?
Again, it goes back to whether a doctor can, in good faith medical judgment...
That's a lot for the doctor to risk.
Well, I think it's protective of doctor judgment, Your Honor.
When Idaho law changed to make the issue whether she's going to die or not, or whether she's going to have a serious medical condition, there's a big daylight by your standards, correct?
It is very case by case. The example
That's
of prom...
the problem.
I'm kind of shocked, actually, because I thought your own expert had said below that these kinds of cases were covered. And you're now saying they're not?
No, I'm not saying that. That's just my point, Your Honor, is that...
Well, you're hedging. I mean, Justice Sotomayor is asking you, would this be covered or not? And it was my understanding that the legislature's witnesses said that these would be covered.
Yeah, and those doctors said if they were exercising their medical judgment, they could, in good faith, determine that life-saving care was necessary. And that's my point, is a subjective
But some
standard.
doctors couldn't. Some doctors might reach a contrary conclusion, I think, is what Justice Sotomayor is asking you. So if they reach the conclusion that the legislature's doctors did, would they be prosecuted under Idaho law?
No. If they reach the conclusion that the Dr. Reynolds, Dr. White did, that these were life-saving...
What if the prosecutor thought differently? What if the prosecutor thought, well, I don't think any good faith doctor could draw that conclusion. I'm going to put on my expert.
And that, Your Honor, is the nature of prosecutorial discretion, and it may result in a case
Does
that
Idaho put out any kind of guidance? You know, HHS puts out guidance about what's covered by the law and what's not. Does Idaho?
There are regulations. DAPA has some regulations, but I think the guiding star here is the Planned Parenthood v. Wasden case, which is a lengthy, detailed treatment by the Idaho Supreme Court of this law. And it made clear, the court made clear, that there is no medical certainty requirement. You do not have to wait for the mother to be facing death.
Counsel,
Thank you, counsel. What happens if a dispute arises with respect to whether or not the doctor was within the confines of Idaho law or wasn't? Is the doctor subjected to a review by a medical authority? Exactly how is that evaluated? Because it's an obvious concern if you have an individual exception for a doctor, and we're having a debate about is that covered by your submission that nothing in Idaho law prohibits complying with EMTALA. I mean, who makes